Hello, I'm Maureen Moakley. Welcome to Access Rhode Island. Today we're really fortunate to have as our guest David Vogel. David is a practicing attorney in Rhode Island, in Providence. And perhaps more interesting, David will be hosting a program on Access Rhode Island, which will give the community an opportunity to hear him discuss with other people issues that are important when it comes to legal issues that we have here in Rhode Island. So welcome, it's delightful to have you.
Pleasure to be here.
And let's begin by talking about how you got involved in questions more broadly than cases that the public might be interested in. There is a documentary that's been made. It's called Hot Coffee. And what it is, my understanding, is a kind of retort to the idea that individuals sue willy-nilly and that we are an extremely litigious society and big corporations are sort of humbled or taken advantage of because of the fact of these lawsuits. Hot Coffee, as I understand, makes the point that, in fact, people sue for very serious reasons. They have cause to sue. And the whole idea of a litigious or frivolous kind of lawsuit culture is not as prevalent as we might think. Could you tell us a little bit about that and your position on that?
Precisely correct. In the documentary Hot Coffee, as you correctly point out, it does make the point that things such as jackpot justice or frivolous lawsuits are not really part of this society. As an attorney, I have seen clients who have made the decisions to sue or not made the decision to sue. I myself was actually a litigant. I had to sue somebody for a breach of contract here in Rhode Island. Mm-hmm. I can tell you that people, when they're faced with having to go into the legal system, do not reach that decision lightly. You may not know this, but for all of the people out there in this country who actually have a case over which they could sue, fewer than 10% of those people ever actually get to the point where they even want to file a case.
How do you respond to the notion of, for example, ambulance chasers, or the ads that we see on television that say, if you have a grievance, call us. We'll defend you. And we know that these attorneys are very wealthy and very successful. How do you respond to that?
Okay, first of all, they're not all wealthy and successful.
Okay, but some of them are.
Some of them are. There's no question, but you're going to find wealthy and successful people in every facet.
So we don't have ambulance chasers?
We do have ambulance chasers, but here's the kind of other side to that, if you will. People that we label ambulance chasers, maybe some of them are, but one of the things that they do, one of the services that they provide to the community is they speed up the process a little bit. A lot of them are quite frankly, settlement factories, where you have a case, you go to them, they get you money almost, I won't say immediately, but within months instead of years. And that's the key.
And generally avoiding a long legal battle.
Yes. When you file a case, and maybe some states are quicker, but in the civil dockets here in Rhode Island, I know that when I filed my case in October of 2007, I didn't get a trial until November 4th of 2010. And wow. I will not get a final decision because the defendant has appealed. I won't get a final decision from the Rhode Island Supreme Court until probably the end of 2012. That is a 5-year process on a case that originated early in 2007. And I only pursued it because there was no way I was going to be able to settle, and I needed to prove a point.
How about the idea that most people have, which may be correct or not, in the sense that, for example, the Hot Coffee case was against McDonald's, I think.
Yes, it was.
And one of the things that attorneys that pursue these kinds of cases are people with deep pockets, and oftentimes you find that they're willing. They go across a broad spectrum of possible directions of the suit, and they'll pick the people with the deep pockets with the idea that, well, they'll pay us off, we can get what we want. How do you respond to that?
Another public misconception.
Good. Well, then tell us why.
In the legal field, especially if you're litigating, okay, if you file a case on behalf of a client against a particular defendant, okay, if it was the case where should have been a different defendant, or if there were other people involved who should have been included in the case who weren't, and you failed to file against those people, you've committed legal malpractice. You are now on the hook for being sued by your client for doing something that literally you should not have done. Therefore, you have to file a suit against a broad spectrum of people in the litigation sense. And as discovery is done, in other words, as you take depositions, as you get evidence, as you move forward in the case, what you are able to winnow out is you are able to ferret out the people or the entities who maybe are not responsible for the harm, and maybe the entities who are. That has nothing to do with deep pockets. That has everything to do with doing your due diligence as a lawyer.
But surely at some point the deep pockets element enters into the discussion, or the emphasis?
The emphasis will only enter into the discussion if two possibilities. Number one, if it really is the deep pockets who are at fault. Or number two, in the case, and quite frankly, there are some attorneys out there who will take the shotgun approach. In other words, they will say, you know what, whether I've got a good case or not, this is what I'm going to do because that's how I get paid. But that is a very small percentage of lawyers.
Now tell us about the hot coffee case per se. In other words, most people I don't think are familiar with it. How did this whole thing start, and what was the ultimate resolution?
To be perfectly candid, I wasn't even familiar with it before I saw the documentary. I was under the impression, because I was, I think when the hot coffee case was
Well, we need
litigated,
to tell people that this was a case where a woman, correct me, a woman had bought a cup of hot coffee and was badly scarred when it spilled.
She wasn't scarred, she was injured. She suffered third-degree burns.
Right.
Third-degree burns going up the inner thighs. In fact, she needed reconstructive surgery.
Right. But at the time when it was announced, it was many people, and the way it was covered in the media it was like a frivolous lawsuit.
I know.
She got the coffee and she spilled it. It was her fault. And what is she doing suing? How did the sort of redefinition of that come about, and how did the documentary underline that?
As I said, when I first heard about the case way back in the early 1990s, when it was long before I became a lawyer too, I was under the same impression. I heard the term jackpot justice. I heard the term frivolous lawsuit. I heard the term some coffee spilled. I heard the term it was it was her fault. I didn't know what to think of it either. And even as a lawyer, it's not something I'm not primarily a litigator, and so I wouldn't have gone back and researched the case for any good reason. So I always had the same thought that everybody else had. But seeing the movie, what became very clear is that while you can make the case that she did spill the coffee on herself, she was not driving, she was not in a moving car, she didn't do anything really that you or I wouldn't have done if we were trying to fix our own cup of coffee. It was an accident. Accidents happen. But the difference was that prior to her actually filing suit, she did go to McDonald's and she said, or she actually, her relatives did because she was still in the hospital, they asked McDonald's to do the honorable thing, which is what they thought was that because the coffee was so hot, and apparently, according to the research, the coffee was a good 40 to 50 degrees hotter than other establishments make their coffee.
Yes.
That is extremely hot. It's literally like putting your finger into boiling water. And they went to McDonald's and they said, look, your coffee was way too hot. We don't know if it was a problem with that machine or if that's a corporate policy, but do the honorable thing. This woman is in her 80s, and just pay her hospital bills. McDonald's basically brushed her off, gave her the cold shoulder, went about its business, and then they said, well, the hospital bills are mounting, we may need some help, and that's when they decided to consult an attorney, and that's how the process started. But it wasn't until they'd actually kind of exhausted all the other possibilities.
What did she wind up with? It was a sizable amount of money, wasn't it?
That depends on how you look at it. I would imagine that her hospital bills were actually in the tens of thousands, if not.
No, I'm just asking. Do you remember what the judge?
She ended up finally with a few $100,000, although it was finally a non-disclosed amount. She got an award from the court, which was reduced, and then she went into settlement negotiations with McDonald's at their assistance, and they settled on an undisclosed amount.
How, just so people that might be interested, how available is this documentary? It's opened recently. I guess there was a panel on it. Where can one access this?
Well, I would imagine you could get in touch with the person who produced it, who is herself an attorney from the West Coast. I don't think it's in theaters. I believe that what she's doing, she's making a rounds of the 50 states, and she actually is selling DVDs of it. So you might find it uploaded online someplace.
Or Netflix,
I don't know.
or something like that.
I really don't know.
But I understand it did.
Actually, she did say Netflix. You're right.
It did sort of turned people's attention in a different direction in terms of the general expectation that people are being ripped off by big companies, et cetera, et cetera. And they don't, they don't, this a whole idea of pursuing this idea just to get money without the litigious, fever that people seem to have.
I'd like to make one quick comment on that. It's not just the matter that people say to themselves, "Oh, I've been hurt. I've got a hangnail. I'm going to sue." It's not that simple. Even if you decide that you want to file a suit, frivolous or not, okay, you still need to clear legal hurdles to even get into court. I mean, you're going to have a really tough time if you've got a really, really, really weak case of getting anywhere near a court, because even if your own attorney is worth their salt, his or her salt, they're going to tell you, hey, you know what, you've really got a weak case here. Either settle it or just drop it. Right. So the fact of the matter is that simply waking up one morning and say, aha, I'm going to sue, doesn't get you anywhere.
Doesn't get you that way. All right, another sort of perception that people have related to this idea is that with healthcare costs escalating and all the problems with reform, there's a group of people that say, look, it's not about the kinds of reform systems that we want. It's really, if we could just get tort reform, medical costs would not be that high. Can you speak to that?
Absolutely a falsehood.
Yeah, and tell us why and how.
Okay. Why is, there's a lot of reasons. We could talk about that for a month. But just look at the graphs. The charts don't lie. The healthcare costs have continued to rise. Insurance premiums have continued to rise. And there are significant numbers, there's a significant minority of states out there that have actually instituted tort reform, as you suggest. And in those particular states, costs continue to go up, healthcare costs continue to go up, and it's unabated. So just looking at the actual numbers of the states that have not instituted tort reform versus the states that have, since you really don't see a lot of difference in the rise, it's hard to make the case that somehow tort reform is doing the job. Okay, and that's the short answer.
But there's another part to that. If you talk to responsible physicians and you look at the numbers, just for example, the amount of money that they have to pay in malpractice insurance is staggering.
Yes,
and I mean, I don't know how you could reframe that.
Nope.
I mean, when you're talking about a third of their salary, it has to go back in terms of insurance. How do you speak to that, given your argument about tort reform?
What do you mean by speak to it? I mean,
well, if in fact we don't have frivolous lawsuits in the medical field, if it's hard to do, why do doctors have to pay a third of their salary and more to protect themselves from malpractice?
A really simple answer might be a fear society. In other words, insurance companies, for better or for worse, who do administer these policies, they have gotten to the point where their algorithms or computer programs or whatever it is that they use to dictate what's going to be the insurance premium have made the determination that if you are practicing this type of medicine in this particular state, here's what you're going to pay. And they've made that determination based maybe upon litigation history, maybe upon settlement history, but however they do it, since I'm not privy to that, it's hard for me to get into their brains and say it, an answer for them. But what I can tell you is, again, you look at the numbers in the states that have tort reform versus the states that don't have tort reform, since the costs and since the health insurance costs, premiums for the doctors, as well as costs for the people, are rising more or less at the same pace, it's difficult to make the argument that somehow litigation is the difference.
Right, but the thing is that there's got to be an explanation.
Of course there's
got to be an explanation. Is it just that the insurance companies are ripping the doctors off?
If you ask me, yes.
That's your opinion.
I was hoping not to go there, but yes,
no, really.
I think so.
What you're saying is it isn't really necessary. They feel as if they can
just look at
give that protection and charge for it.
Insurance companies are making more money than they could possibly know what to do with. They're giving their executives higher pay than you and I will ever dream about making. And doctors are getting slammed with the premiums, and people are not getting the coverage or the care that they deserve. So you do the math. Yeah.
So what you would argue, and it's perfectly reasonable, that the kind of culprit in all of this is the insurance policies and the insurance people who are making all this money because they have this leverage. And what about regulatory policy?
This is something that I feel very strongly on.
Okay.
And something I asked a panel member when I attended the hot coffee presentation. a lot of people don't realize the history of corporations in this country, and I won't go into the 230-year history of corporations.
Good, but just tell us the short of it. Okay.
The short end of it is that there's a dividing line. The dividing line is late in the 19th century. Prior to that dividing line, corporations were treated as the creatures of statute that they are. And by creatures of statute, I mean laws created them, laws allow them to be created, I should say, and laws control them. Corporations are not people. They never were meant to be people. At a certain point in history, late in the 19th century, corporations took on personhood when a very clever corporate attorney made the argument to the Supreme Court of the United States that corporations should be treated as people, and the court bought it hook, line, and sinker. Ever since then, corporations have been enjoying the best of both worlds. And by that I mean that they get treated like people when the laws suit them, and they don't have to act like people when the laws don't suit them.
Right, and it's particularly egregious from my perspective, because from what I study is, of course, when it comes to campaign finance and that kind of thing, that they have this kind of exemption in terms of the monies that they can spend. Do you see any likelihood that this position will be overturned? Is there any indication out there from a point of view of personhood vis-a-vis free speech and the kind of things that I'm concerned about in terms of advertising, and what you might be concerned about in terms of their ability
policy?
To
The only way I see that happening is at the state level. I don't see it happening at the federal level.
Do you know of any states that have made an attempt to even begin to make that argument?
Vermont comes the closest.
In what way? What do they do in Vermont?
Vermont has very, very, very strict campaign finance laws.
Right.
Very strict.
Right.
If I understand correctly, I think the last time I checked the Vermont laws, which wasn't too long ago, I think they place a cap of $100 per person for a donation to any individual.
But how do they deal with the personhood thing?
Well, they treat corporations like people, and they say you can only donate $100.
Right, but that's got to get into, we're going far
yes,
afield
I
here,
understand.
but this has got to get into free speech aspects of First Amendment.
Okay.
But in any case, but that's interesting what you say in terms of how it works in the medical profession, because it is a huge campaign kind of position that a lot of candidates have. If we could just get people to stop suing, we could solve the problems.
So maybe candidates have that, but even if we can't get people to stop suing, I've thought about the issue, and there is a mechanism that I think that could be employed that we have in Massachusetts. I'm a member of the Massachusetts Bar. And when you file a medical malpractice case in Massachusetts, before you can file the case, you are actually required to take the case in front of a panel, a board, okay? And the board they have no legal authority to stop you from suing. But what they do is they pass on the merits of your case.
What board?
It's a board I forget if it's the MACD or the MCAD. I think it's MCAD, and I forget what it stands for, but it's been a long time since I've actually had to do it.
But it's like professionals. It's not judges per se. It's pre-trial.
Judges, lawyers, and doctors.
Oh, okay, good.
The board is always made up of at least one person from those three professions, okay? And they pass on the merits of your case. And while they legally can't stop you from suing, they say to you, okay, you have a good case or you don't have a good case. If they say to you don't have a good case, as I said, you can't be barred from suing because we all have a right to the courts.
Right.
But it does two things. First, you have to post a bond to actually go sue. And secondly, it kind of gives you the heads up that maybe you shouldn't be taking this case into court. And it kind of works as an unclogging of the system. I don't think it would be so difficult, and this is kind of going back to the hot coffee and the caps on damages. I don't think it would be so difficult, and I don't think it would be so egregious for states to adopt a Massachusetts type of board system where if you have, let's say you have a state where there's caps on damages. Okay, fine, legislature decided it, fine. Okay. But if you have a case that could easily surpass the cap on the damage, and you can make that case to a screening board beforehand, I don't think it would be such a bad idea if even a state like Nebraska or Texas or other states that have these caps on damages were to hear that evidence by an impartial board and say, you know what, this is a case that is so bad that we can't put a cap on it. Go forward.
All right.
I don't think that would be so bad.
Any indication that you've seen a difference, for example, because they have these kinds of board in Massachusetts that has to do with the number of litigations or the type of litigation? Is there any evidence that this has made a difference in terms of,
and
in what way?
And I can't give you, I don't have the numbers, but it does go a long way towards reducing it may not, maybe when a person is injured, because they're not lawyers, they may not understand, but it certainly goes a long way towards the legal community in Massachusetts being able to rein in the expectations of would-be clients and say, you know what, if we go in front of the board, if they say you have a great case, wonderful. If we go in front of the board and they say you don't have a case, you might want to rethink this.
Yeah.
And like it or not, when an attorney tells you might want to rethink this, 9 times out of 10, somebody's going to say, okay, fine, I'll rethink it. Good. All right, let's talk about your real specialty and the thing that you're most interested in, and we all are these days, and that's the question of immigration and immigration law. As I think most of our audience might know, that different state, we have a sort of unenforced vague policy at the federal level, and so different states have taken up their sort of the charge, if you will, to suit the culture and so forth, and we have a plethora of rules and regulations that are state by state, vastly different. Vermont's, for example, is very generous when it comes to not being able to infringe on the rights of people that you suspect might be an illegal immigrant. And there's, drastic ones in Alabama. And of course, there's one that got a lot of recognition in Arizona. Yes.
And the Supreme Court has just announced today, as a matter of fact, that they are going to take the Arizona case. Tell us how you feel about where immigration law is going, and most, generally, and how do you think we're doing here in terms of the kind of contentious issues we have in Rhode Island?
Yeah. I'll start by saying that with respect to the Arizona law, and I'll just spend 10 seconds on that, the court is only going to be looking at certain portions of that law, and they're only going to be looking at it on the basis of preemption. In other words, preemption being a concept where if the federal law is overarching, and if the state law infringes on the federal law area of jurisdiction, that they'll strike down the state law based upon that. The court is only going to be looking at it on the very, very narrow issue of preemption. So my personal feeling is, with respect to that law, I don't think it's going to change much. In other words, even if the court decides to strike down parts of it, it's
parts of the Arizona law? Parts
of the Arizona law. Right. Even if they decide to strike down parts of it based on preemption, I don't think it's going to change very much in a practical sense, because the other parts that have been left alone are still going to be enforced and enforceable. So in that case.
But the interesting thing about that is to me anyway, is why did the court take it right now? That's the real question. Why did they choose?
That's a really good question, too.
And I mean, that's the key. That tells you more about where they're going than, what the actual decision
Well, I'm glad you know where they're going, because I actually don't.
But I mean, in other words, they're interested in that aspect of it.
Yeah.
And what does that tell you about what's going on across the country?
Okay. What it tells, it doesn't tell me much about what's going on across the country, but it does tell me about what I think the federal court system feels about the dichotomy of the federal system and the state system. What I was going to say next is that, with respect to another part of your question, the state by state enforcement of immigration laws, there's not really a good reason for states to be quote unquote enforcing immigration laws in the way that they're enforcing them. I understand the argument that the federal system is, as you would put it, vague and unenforced. It's not vague. It's actually very clear. Yeah. The vague part comes in because there is a certain amount of discretion that's allowed among federal officials to enforce the laws. But the unenforced part comes in because, and this has to be laid at the feet of Congress, our Congress has decided really not to fund the United States Customs and Immigration Service. Department of Homeland Security has, I think for 2012, a $57 billion budget. And USCIS, United States Customs and Immigration Service, which is the administrative agency that's charged with dealing with the people who are actually here, has a budget of under $3 billion. Now, I'd love to have $3 billion in my bank account. I think it'd be very well off. But for a federal agency that is charged with dealing with 50 states and the Northern Mariana Islands and Puerto Rico and Guam and the District of Columbia and whatever else you want to talk about, That is hardly anything at all. The USCIS, as a matter of fact, 99% of its budget is actually fee-based. In other words, if you need a 612, if you need
what's a 612?
Okay, it's an I-612 is a waiver form for certain conditions. If you're married to a United States citizen and the United States citizen wants to petition, when you file those forms, there's charges. Okay, there's simply charges.
So in other words, it's fee-based. It's not fun.
It is not funded by the federal government.
In the time we have left, tell us about what you think about the issues related to immigration in Rhode Island and how you might get involved with cases here.
Good question. Rhode Island, I think, is starting to get it right a little bit. They're starting to recognize that we do have undocumented people here, and that they are parts of society, whether you like it or not. Most of them are contributing parts of society. People who come here, and I know a number of undocumented aliens here, not just Rhode Island, but the United States in general, friends all over the place. People come here and they work. They are productive members of society. They have real skills. They are not monsters. They are not criminals. They are not thieves. They are not here for the wrong reasons. They're here because they want to improve their lives.
But how do we deal with the problem?
And Rhode Island is taking the right steps.
In what way?
Rhode Island, the education bill, or the education allowance, I think is a good step in the right direction. Being able to, for these people to be able to get an education at a state school at the same tuition that in-state residents would get. I think that's a really good start. The problem, and I was going to mention this a minute ago, the problem is that when you have the interplay between state governmental enforcement and federal governmental enforcement, you're not getting at the root of the problem. In other words, there's still no way for a state to grant legal status to anybody who's in this country illegally.
Now, could the Supreme Court decision impact that in any way?
I don't see a way
that it could.
I don't see a way that it could, because in order for them to do that, the Supreme Court would have to somehow rule unconstitutional the whole basis of federal preemption. I don't see that possible. I don't see that as possible.
Well, there's a lot more to talk about.
Yes, there is.
And we really look forward to the fact. Tell us, just very briefly, you're going to have a program on Access Rhode Island and talk to the community about issues that have to do with the law and immigration.
Yes.
What are the other ideas do you have?
Well, I mean, you mentioned it earlier. I mean, tort reform is an enormous area. I actually started my career as a federal tax lawyer. Not that I'd be giving tax advice on the air.
I don't think a television program with tax advice is a great idea, but go ahead.
But I understand, and I agree with you, but the point is that, but overarching principles and concepts.
That would be great.
Yes.
Yeah.
Good. So it'll branch off into areas that would be relevant or hopefully interesting to people without making their eyes glaze over.
We absolutely look forward to it.
Thank you.
We welcome you back to this community.
Thank you.
And we look forward to seeing you in and about around town and also on Access Rhode Island. David, thank you very much. It was a pleasure to meet you, and we wish you well.
Thank you.
Okay. Bye-bye.